20 TRD 01382. This is a driving under suspension. This is it? That's all he has from his time? Mr. Holland, how long have you been in jail? Since last night, all right. So your driving under suspension is based on the fact that it looks like maybe you failed to appear to court when this first happened. So what I'm going to do is go ahead and enter the plea of not guilty for you today. It looks like this happened on April 28th of last year, Taylor area. I'm going to enter a plea of not guilty today and set a pretrial for you to come back on June 16th. The goal is on June 16th to have your license or at least have insurance or do the best you can in that regard, and we'll see you then. But just don't forget to come back to court so you don't end up spending any time in jail. And you'll be released today. Counsel, go ahead.
I believe he told me that there's a block on his license from this case, from his failure to appear.
Okay.
He has been trying to get his license straightened out, so he would request that block be lifted.
All right, so it'll be a plea of not guilty. Bond is a $5,000 personal bond, so you will be released. And when you are released, you come back up to the clerk's office and they'll give you the paperwork you need in regard to your license. All right. You can have a seat. Dwayne Hayes. Mr. Hayes, 21 CRB 00351 is a charge of domestic violence from April 11th of this year. And they're saying that you struck an Erica Jones on the face. Madam Prosecutor, it looks like you are amending this. Is that correct?
Correct. We met with his wife yesterday. She signed a refusal to assist. She says that nothing like this has ever happened before, that and they've been due to the stressful situation. They had some real property and the tenant that damaged the property. And that led us to an argument, but they had a lot of business interests going together, and she doesn't want a no contact order. She wants them to be able to continue their relationship and handle their business, basically.
Ms. Johnson, anything to add or subtract from that information?
Ron Johnson, this is advocate for the record, and we said everything that I know is to be true.
All right. So, Mr. Hayes, just so you know, normally with the domestic violence, you're looking at up to a $1,000 fine and 6 months in jail, and the domestic violence goes on your record. And every time it happens again, it increases. And I think we may have some of those situations coming up. And I very rarely accept the amendments to a disorderly conduct, but I'm accepting what the city has stated, as well as Ms. Johnson, who spoke with the other party. So I believe what they're saying to be true. And with that being said, sometimes we lose our temper, we lose our cool, but you see what happens. It's so easy to get caught up in this legal system. So use this as that opportunity to say, you know what, never again for that. So I'll go ahead and accept this amendment at this point. It'll be disorderly conduct. How do you plead to that charge? All right. And based on what was stated by the city, there'll be a finding of guilt. It'll be a $500 fine plus costs, 0 days in jail. And Mr. Hayes, I'm going to trust everything that's being said, and I'm not even going to put you on probation at this point. But this is that one opportunity to say, okay, I dodged a bullet, and make sure that, you know, your communication just doesn't get to the level of violence. All right. Any questions, sir? No. So you'll be released from jail today. You can come back up and handle taking care of your fines and costs. And if you need a payment plan, we'll work with you in that regard. I appreciate it. You're welcome. You can have a seat. Thank you, everybody. All right, Clarence Ward. Mr. Ward, 21 CR 800380, a domestic violence charge. And this is where there's an indication that there must have been a previous conviction of a domestic violence, because they're alleging that on or about April 10th, you did partake in an argument with your brother, escalating to a physical altercation, and then there was a bite and a damage, possible injury to an eye based on this altercation. How long have you been in jail, sir?
Since Saturday morning.
All right. So about 5 days. And did you get a chance to speak with the defense attorney, Mr. Humphrey, the gentleman there to my left? Mr. Humphrey, in regard to the preliminary hearing, how are we proceeding?
Your Honor, initially, before we begin, the court will note that the file originally said it was a felony 5. The prosecutor did provide documentation of that prior, which would make this a felony of the third degree. I did have the opportunity to explain that to my client.
Okay.
Regarding the preliminary hearing, at this time, he would waive the preliminary hearing, maintain not guilty, and he would request to be heard on bond, Your Honor.
All right. So, Mr. Ward, that means the case is going to be sent to the county. You're still not guilty as it stands right now. Your court date is going to be Monday, 12th floor of the Justice Center at 9:45. Detective, on the bond?
Yes, sir. You have Mr. Ward in front of you, sir, with a 14 cycle arrest record. Arrest for burglary, CR 115495339, and domestic assault hooked up together 1963763, and disrupting the public service, CR 1963763. The bond that we requested was 60,000 surety, Your Honor, but due to the facts that I heard and everything, we have no problem with any kind of deduction.
Okay. Counsel, where are you in regard to the bond?
Your Honor, so if I could put some facts unrelated to the specific facts of the case prior to me making my request. So I did have the opportunity to talk with the victim advocate this morning, as well as the prosecutor and the detective on this. It is my understanding that the alleged victim in this case has essentially refused to assist and has requested that no charges be filed. Obviously, my client and I are aware that alleged victims don't get to drive the boat when it comes to charging and prosecuting cases. I have further requested that the detective, when the file be sent downtown, request that the victim be subpoenaed to grand jury so that if he's going to avail himself, that it's done earlier rather than later. I think all parties anticipate this case probably ends up getting dismissed downtown because of the victim's refusal. Did have the opportunity to talk with my client about his ability to pay, and we would be requesting a $7,500 10% bond on this, Your Honor, and maintain a no contact with the alleged victim during the pendency of any case.
Detective, is there an objection to that?
No, sir.
All right. So without the objection and based on the information provided by defense counsel, I will go ahead and reduce the bond to that amount. And I'm going to go ahead and impose the no contact order. So that means until the judge downtown lifts the no contact order, you can't live with or communicate with the alleged victim, who is your brother, correct? All right. You understand all of that? All right. You can have a seat.
Thank you, Ron.
Thank you. All right, Landon Coleman. All right, I have a misdemeanor charge in 21 CRB 00373, contributing to the unruliness of a minor or a child, where they're saying that on or about April 12th, you did allow a juvenile to obstruct police during a vehicle pursuit by allowing him to flee from police on foot. Question, is this going to be attached to the felony, or are we keeping that separate? All right. All right, so then the felony charge is 21 CRA 00374. The charges are tampering with evidence, failure to comply with an officer's order, child endangerment, improper transportation of a firearm in a motor vehicle, as well as carrying a concealed weapon. And how long have you been in jail?
Since Monday.
All right. All right, so failure to comply with an officer's order is a felony of the third degree, 9 to 36 months in prison and a $10,000 fine, where they're saying that on or about April 12th, you did fail to stop for a signal of police, fled from police until crashing into a stationary vehicle in the city of Cleveland. You drove in excess of 75 miles per hour in a construction zone with a minor in the vehicle with you. Then you proceeded to flee from officers on foot until eventually taken into custody. Then there's a felony of the fifth degree, 6 to 12 months and a $2,500 fine because they're saying that you had a weapon on your person, an armory revolver with a specific serial number, and this was on or about April 12th. Then there's a felony of the 4th degree child endangerment, 6 to 18 months and a $5,000 fine because they're saying that on April 12th, you did create a substantial risk of safety to a child by violating the duty of care, by driving at approximately 75 miles per hour in the construction zone with a minor in the vehicle and reckless operation. Then there's a felony of the 3rd degree tampering with evidence, 9 to 36 months and a $10,000 fine because they're saying you did have a loaded firearm on your person, but you discarded the firearm while fleeing from police on foot. Then there's felony of the 4th degree, 6 to 18 months and a $5,000 fine because they're saying that on April 12th in the city of East Cleveland, you had a loaded firearm on your person in the motor vehicle. You had a chance to speak with the defense attorney, correct?
Yes, Your Honor.
All right. And how old are you, sir? 18?
Yes, Your Honor.
All right. Counsel, on behalf of Mr. Coleman.
Your Honor, we're talking to Mr. Coleman at this time. He maintains his innocence. We will waive the preliminary hearing and request to be heard on bond.
All right. So again, with waiving the hearing, you're not admitting any guilt. You're maintaining not guilty. The case will be sent to the county for further proceedings. You understand that?
Yes, Your Honor.
Your court date will be set for Monday, 12th floor of the Justice Center at 9:45. Detective, on the issue of bond.
200,000 surety, Your Honor. That's because Mr. Coleman here has a count of 27 counts in juvenile. Evidently, he did not learn his lesson. He was charged with aggravated robbery, 1st degree, and he has 2 cases that he had firearms for 1 year specs and a 3-year specs. He's currently on probation in juvenile. Spoke with the juvenile officer. He said that he's very disappointed at him because he used to do everything he says, but evidently he's gonna bring it back in front of the judge once he get downtown, and then asked him for him to be adjudicated over.
Is there a hold on him from juvenile court? From the
They
probation?
want it.
Okay. All right. Counsel.
Also, Your Honor,
I'm sorry.
counsel talk. Pictures for you to look at that he did in that vehicle with that minor inside saying that was not over the age of 18. Both of them could have been killed.
All right. Counsel, go ahead.
Your Honor, what I will say is several things. On one hand, I appreciate the detective saying that he talked to the probation officer and that my client was compliant with probation. I would use that as an argument to the court that he's got every intention on appearing at a court hearing, handling his business. One thing I do disagree with is a statement of that he hasn't learned his lesson. The purposes and principles of bond is not teaching people a lesson. It's to assure his appearance at court while balancing the protection of the community. So whether he's learned his lesson or not should not apply in setting bond, Your Honor. I did have the opportunity to talk to Mr. Coleman and tell him this court's position on failure to comply. I'm out here enough to know how the court views those and sets bond on those. What I would state is that a $200,000 request is somebody who's probably currently representing 60 or 70 felony clients, some of them on life rapes. None of them have a bond anywhere near $200,000. That's just not appropriate in a case like this. We understand the serious nature of this. My client understands the charges, but we would ask for something more appropriate in the 30,000, 10% range.
All right. And Detective, I sound like you are objecting to any reduction at this point.
Yes, sir.
All right. So, Mr. Coleman, a couple of things. One is I'm going to go ahead and accept that you waived the preliminary hearing, which means the case will be sent to the county. I'm not sure what's going on in regard to the juvenile court situation and whether or not they're going to put a hold on you, which means you won't be able to post a bond at any point, no matter what I reduce it to. So keep those things in mind. The other thing I want to mention, this is for you and everyone else, As council knows, the bond that I set here is the bond that gets you from this court to the county court. Once you're downtown, that judge can reset the bond as they see fit, because that's going to be the judge that's going to have your case throughout its entire proceeding. They can give you a higher bond if they felt that was needed, or even a personal bond. It all depends on that judge. Whereas my bond is just from here, basically almost until Monday, if you get out of here. Now, couple things. I don't mind the request for the reduction, and I think, have you spoken with anybody? Are you able to post a bond at all? Because the reason I ask that is because I'll reduce the bond, and I'm gonna tell you why. But I don't know if you're gonna be able to make the bond that I reduce it to anyway. But nevertheless, I'm reducing the bond first of all, Mr. Coleman, because you're 18 years old, and I believe, you know, despite what's being said, I believe that you have your entire future ahead of you, and you can turn it around whenever you simply decide to. So it's important for me to know that you've had that history, but then at the same time, I believe that you can supersede that history. You can go beyond what your past has been as soon as you make that choice. And the thing about the fleeing and eluding that both parties are saying, it has become very concerning to me because it's happening so much. I mean, I would have to say, I can't imagine what the detective and what counsel sees as private attorney, but I see at least 3 or 4 of these a week in this court, which means to me it has to be happening all over the place. And I'm not sure why it's happening at this level. I understand that there may be an untrust between the community and police, so you don't feel comfortable stopping. But I just saw a few pictures, and that is normally the result. Either your car is injured and you've hurt yourself, or somebody else's. I saw at least one other car of a person that you probably didn't know, probably wasn't involved, but that car looks like it has to be totaled. So that could be a single mother, single father who now all of a sudden has to find transportation because of what you were, avoiding. Then even worse, I've seen people in this courtroom with cases where they've hurt other people. So that person wasn't a car, but they're in the hospital because of a chase. So if there's something going on, and if there's a chase and you don't feel comfortable, I would say now call 911 yourself. Tell them who you are. Tell them where you're at. I'm on Euclid. I don't feel comfortable. I think this police officer got it out for me. I'm going to drive to McDonald's and I'm going to pull over where I got 50 other people in the parking lot. I mean, something to protect yourself, but this is not the way to do it. And I'm just saying that in case I never see you again. See, counsel wants to mention something else to me. Go ahead.
Your Honor, with request to what I requested for bond, that was in discussions with Mr. Coleman and the potential to post bond. I mean, a $200,000 bond, a $100,000 bond is essentially by virtue giving him no bond.
No bond.
He's indigent. He's 18 years old. He does not have the ability to post any bond that counsel would deem to be excessive, Your Honor. Okay.
So I understand that. So what I'll do, Mr. Coleman, again, the detectives are requesting $200,000. Your attorney is requesting 30. Again, I'm sure I won't be able to satisfy either party on that regard. And I'm just going to go with what I have. It'll be a $75,000 bond. Hopefully that'll give you some leeway to get out. But if not, again, that bond is in place officially until Monday. Once you see a judge downtown, they can reduce it based on all these other factors. 10% of surety. But most importantly, because again, this, I'm not holding against you. I mean, of course, you're going to have to fess up or at least deal with what you've done. But I believe at your age, and even no matter what age you guys are at, you can always turn it around whenever you decide to, because this does not have to be your future, standing in front of a judge where people are talking about your past. Let this be the last time they talk about your past, and now they're going to be talking about the great things you're doing after this case and how, man, he's such a different person than he was with all that other stuff going on. And I really believe you can do it. All right, you can have a seat, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, before I get several of the gentlemen requested a phone call for.
Okay. All right, we'll make sure we can get that done for you. Yeah. All right. Mr. Watkins, 21 CRB 00349. This is a domestic violence charge. And this is a misdemeanor of the 4th degree, correct? It's a threat,
I believe so, that's correct.
which means you're not subjected to the 1st degree misdemeanor. It's a little bit less. And it's not an escalating event, which means regardless of how we resolve this case, this doesn't put you in jeopardy of having a felony charge next time. So the good news is that you're charged with a DV, a lower level. And what they're saying is that on April 10th, you did threaten to kill your wife by means of a firearm. So it's not an insignificant charge, but it's being charged in a lower offense. And that's in 21 CRB 00349. I'm going to hear from the city prosecutor and maybe the defense attorney because this was miraculously reduced to a minor misdemeanor.
Yes, the victim in this matter, his wife, Chappelle, was in the courtroom. We spoke yesterday. She executed a refusal to assist form. Apparently, there are some other potential charges in Cleveland as well. And he may have a warrant for his arrest, so that you may want to look into that before he is released. So just to minimize having to go here and there and everywhere for the same kind of offenses. Plus he also has felony stuff pending, which doesn't relate to this. So since this is just a threat version, she was comfortable with just reducing it to the minor misdemeanor and dealing with whatever other issues they have that are more serious.
Okay.
Later.
And ma'am, you're the wife, and are you? Well, Miss Johnson, is there a no contact that will remain?
She does want to know a new contact.
Okay. All right. So what I'd like to do is this. So you understand with the no contact, that means you can't go back to the residence at this point. And there may be a hold on him. Is that correct? From the other situations?
Potentially.
So what I'd like to do, Mr. Watkins, at this point, because of all these other things going on, and this being your first appearance before me, how long were you in jail? So about 5 days? 5. Okay. So what I'd like to do is I would like to, if you are guaranteeing me, which you have to do, that you're going to have no contact right now, I'm going to order that. So you have to find another place to go. And if you have items or clothes at your residence, you have to have a police escort to go there. So the no contact means no contact. And what that means is technically you and I are going to work this case out. And I'm going to tell you how we're going to do it. But when I give you a no contact order and you violate that, that's 6 months in jail all by itself. And then we start dealing with the other stuff. So don't do that. Don't put yourself in jail simply on a no contact. So what I'm willing to do is release you from jail with the no contact order, allowing you to go back with a police escort if you need it. And what I would like to do is give you another time to come back before me so that we can get more information on all the other stuff that is going on before I reduce this to a minor misdemeanor. So if it turns out that, yes, there are things going on in Cleveland and you're dealing with that and maybe felony charges, I want you to be transparent with my probation department so they know what's going on. And then if there are other cases that you're dealing with that supersedes this one, or you're going to be in the justice system, Madam Prosecutor is right. I don't need you to be on probation to me and 3 other courts. We'll find out what's going on. So I'm not going to resolve your case today. I'm going to release you today, though, and give you a time to meet with my probation department so they can find out what's going on with you and everything else, and then give you a chance to come back before me. And then this deal that they worked out is still on the table, though. You understand all that? So you don't lose the deal. No contact when I release you, meet with probation and come back when we give you that date. And you'll give them the date to come back?
Since this is not a PSI fully, Your Honor, we can set this if you want on the May PD document.
May PV doc. Okay.
Yes, sir.
So the day that you're going to return to me will be May 27th. May 27th at 1 o'clock. But I'm going to have you meet with probation. What day can I have a meet with either of you?
Whatever is available, Your Honor.
Every day.
It's fine.
4/19. So you're going to meet with my probation department Monday at 10 o'clock. All right. Any questions about that, ma'am?
No,
About-
we stay with each other and I live my life and he live his life.
All right. Any questions, sir? So again, this case is not over. I'm not resolving it. I'm letting you out. No contact. Come meet with probation on Monday at 10 a.m. And I'm going to see you back on May 27th. At that point, I'll know everything that's going on. We'll see where things are. And then we'll see if this is a deal that the court is going to accept or not. Okay. All right. You can have a seat.
John, can you just note my objection to the court?
Yes. Okay. And for the record, I will note that defense attorney is objecting and he would rather have this case resolved as negotiated today. Correct?
Yes, I do have fundamental concerns with a client meeting with probation. Not that I have any issue with probation prior to resolving a case,
Okay.
because inevitably it is highly likely that they would disclose relevant information about a pending case before the court.
Okay. All right. I will accept that. And just the reason I'm doing it, if I don't think that may give you any comfort, but it's not. I don't necessarily want you to give me an opinion on what the court should do. but I would like to verify what was made on the record in regard to the other situations and why the city is willing to reduce it. If there are other charges, if there are other courts that he'll be dealing with.
I think it's been confirmed that the same two parties have a pending felony case downtown.
That's the thing though, they don't have it as of yet, that's what the reason, they're supposed to be charges forthcoming, they have not been placed on there yet, so that's why we wanted to give them some time to make sure that that case was actually gonna be in Cleveland before we resolved it here.
Plus, she has a hearing tomorrow scheduled for a protection order.
Right.
Okay. But I understand. So I will accept your objection
I
though.
just wouldn't want him meeting with probation and talking about any specific facts about this case that would be
No.
relevant to his guilt or innocence.
Okay. Yeah. All right. Yeah. So you understand what counsel is saying on your behalf. Basically, he doesn't want you to disclose anything that could have a bearing on this case. And I just want you to know, my overall goal at the end of the day is that when we resolve this case, I want to make sure that you are positioned to get some skills and tools so that you won't be back before court. So I don't feel comfortable resolving your case in a way that says, okay, just walk out the door, good luck. And then everything else falls apart and then you've never gotten any help. I'm all about putting you in a better position. Something went on where you can get some skills to communicate with either your wife or somebody else better so that you don't end up in front of a judge. That's my main goal. Go ahead.
Can I make one more request, Judge?
Yes.
I mean, again, I have no issues with probation. Can we just have this case? It is certainly within the purview of the court not to accept a plea today and continue it out. Even more so concerning to me is, even though I don't represent him on any potential felony charges, is again the same argument. If he goes in and discloses anything related to those felony charges that could subsequently be used against him in a prosecution downtown,
Okay.
that would be malpractice.
You know,
So-
I believe there's a felony.
But you know what I could do? What I could do, this is real easy. I understand. What I could do is we're in the middle of April anyway. What we could do is reset this for the probation docket and just allow through your communication with the young lady and we can find out on the record what's happening as opposed to a private meeting with probation. So I get that. I appreciate that. So you understand now you're not going to meet with probation. You're going to come back to me on May 27th so I can find out what's happening with these other cases to see if they exist.
So
That's my
essentially
concern.
For him, it's just reset for another pretrial.
Yep, another pretrial.
Okay, thank you.
You understand that?
And just for clarification, the felony I mentioned, I believe, is completely unrelated to anything. It was something that was already filed, and I believe he has court on the 26th.
Yeah, he don't want you to say anything. I'm like again. So, okay.
Unrelated.
Okay.
Unrelated, I'm saying.
So yeah, let's find. So what we'll do? Let's just reset it. That makes sense. That way everybody's protected. We'll reset it so I can find out on May 27th what has or has not happened, and then we'll go for figuring out what we're gonna do here. All right. All right. Thank you. So you're still gonna be released from jail today. I'll still give you that personal bond based on what was presented. There may be a hold though, maybe or maybe not. I don't know. So pre-trial is set May 27th at 1 p.m. How long have you been married? Okay. You have any children? Okay, okay. All right. All right. Anything else, counsel?
No, Your Honor.
All right. And the next one we have is Mr. Wells. Mr. Wells, come on up. Mr. Wells, 20 TRD 01797 is driving under suspension, and 20 CRB 00377 is drug paraphernalia. The drug paraphernalia is from this year, April 13th. The driving under suspension is last year, May 18th. How long have you been in jail? 3 days? All right. So it looks like we're maintaining not guilty on the driving offense, trying to give you a chance to get your license. Are you going to try to do that? Okay. Madam Prosecutor?
Yes, we're asking that this matter be continued to Monday. The drug paraphernalia charge came in connection with fresh domestic violence incident, which this would be, I believe, his third. So that needs to be reviewed and charged. So we're asking that this matter be continued to Monday to have those charges issued, and then that paraphernalia charge would then go with the felony.
So we're gonna maintain not guilty on the drug paraphernalia and the driving under suspension and reset this for Monday, which is the 19th. And counsel, just so you know, based on what I'm hearing, I'm reluctant to set a bond at this point because it sounds like it may be a third DV. Any information on that, Ms. Johnson?
For the record, I will state that this is, from my understanding, this will be the third. This victim is been a victim of his twice. I believe it's his wife. So I would actually be inclined for him not to have a bond at this point as well.
Counsel?
Your Honor, I respectfully would say with no pending charges before the court, it's hard to consider what he may or may not be charged with. He's presumed innocent. There's 2 misdemeanor charges before the court. We've pled not guilty on them, and we'd ask for an appropriate bond based off of those 2 misdemeanors. If this alleged domestic violence incident subsequently gets charged later today or tomorrow, there's a possibility that that would be within the state's power not to release him. But for the purposes of today, what counsel and his client has before him is 2 misdemeanor charges. So we ask for an appropriate bond on those, Your Honor.
Madam Prosecutor?
Yes, Mr. Wells was alleged to have gotten intoxicated and started an argument with his wife. She wanted him to leave because of the argument. When he wouldn't leave, she pushed her from the doorway. He knocked her down and then stomped on her leg with his foot, threatened to kill her and her son. There were injuries that were noted and photographed. And it was in connection with that they found the pipe, which led to the drug paraphernalia charge. So, and since this is not his first incident, both of the other incidents came out of the city of East Cleveland. So we're well aware of Mr. Wells' background. And the last case was sent downtown on a felony 4. So I believe it would be appropriate to hold him until the charges are pressed.
Counsel?
Your Honor, what my client tells me is he's been downstairs 3 days.
2 days.
2 days? Okay, so I mean,
Okay.
within the confines of the law, they have 72 hours to charge him. I mean,
Get charged with 1. And we got to invest on this one, so he'll be up.
so, Your Honor, again, I renew my motion. I mean, if they're gonna charge him with it, charge him with it. If not, he's presumed innocent. And
Okay.
they've got 72 hours to charge him. They can charge him with it. He's before the court with 2 misdemeanors. I ask that he be treated like every other misdemeanor defendant, and appropriate bond be set.
All right. Mr. Wells, I'm hearing all the arguments of the parties, and I respect everyone's position and wishes. What I'm going to do at this point is I'm going to have you come back up on Monday. I'm going to err on the side of caution. I know there's an objection from the defense attorney, but because I don't know much of what's going on, I just think just to be careful with a pending possible domestic violence, and it may be more than once that you've been before me with that. I'll have you come back up on Monday. And on Monday, we need to have some traction, either a charge or something, so we can let him out on a bond. Or
It'll be there.
all right, you can have a seat, sir. Terrence Allen, 9:30, yes.
There's no contact.
How about a Mr. Allen?
No charges.
Come on up, Mr. Allen. Oh, all these gonna be the same day? All right, so counsel, everything else is, so old cases are gonna be set for May, but are any of the misdemeanors going with the felony? Criminal trespass, maybe? Nope.
I don't believe there was a
None of them.
misdemeanor on the same day.
No.
All right. So let me do this. The first case I have in front of me, the felony is 21 CRA 00376. It's a charge of felonious assault, where they are alleging that you committed a second-degree felony where you subject yourself to 2 to 8 years in prison and a $15,000 fine, because they're saying that on April 8th, you did knowingly cause serious physical harm to Mr. Spoon by means of stabbing him in the thigh with a knife. Did you get a chance to speak with the defense attorney?
Yes.
Mr. Humphrey, on behalf of the defendant.
Your Honor, at this time, after talking to Mr. Allen, he maintains not guilty. We'll wait the preliminary hearing, and we would request to be heard.
we'll give you a reminder. And Detective, what bond are you requesting at this point? Is that it? Last one? Detective, bond request?
We requested 150,000 surety, Your Honor. You have Mr. Allen in front of you. 52 cycle arrests, 20 convictions, theft times 6, drugs times 4, attempted robbery times 2, possession of drugs times 4, trafficking in drugs, attempted escape, unauthorized use of motor vehicles times 2. We're asking for 150,000 surety, Your Honor.
Counsel?
Your Honor, after a brief discussion with the prosecutor, I believe they would concede to reducing the bond. We think a more appropriate bond, given what we know about this case, to be 30,000, 10%.
All right. So, Mr. Allen, a couple things. You know you're going to come back to me on all these old cases. I have 6 cases, old cases that you never came to court on it. And what happens with your bond, though your attorney is requesting a $30,000 surety, it's hard for me to even do that when you don't come back to court on these little cases. So what does that mean for me that you're going to come back on these big cases?
What I say is this, I apologize for all that. What happened in the past, you know, I just apologize as a man.
All right.
You know,
So
I'm just trying to get this stuff over. Believe me, I want this out of my life. All this.
you know you can't be out in the street committing crimes, right, and fighting and all that stuff. But don't say anything about it.
That's good.
Don't say anything about it. Thank you. Thank you, Detective. Your pretrial on those other ones will be May 20th at 9:30. And your preliminary hearing is Monday on this felony charge, and the bond will be the $30,000 surety bond. You can post that, all right? You're welcome. Good luck, everyone. Give him that.
Mr. Allen, I want to let you know.
And May 20th, right?
The record,
Say May 20th.
don't exist. It's not there.
Okay, you want to talk to me? Because I'm about to walk out, run to the gym if I can. What's going on?
Is there a number of days that she had to do interlock?
18. What, an interlock? I don't know. What's the rule?
I don't know, because I don't know what the guidelines.
Yeah, I don't think-
The one, and interlock was on here, and her attorney mentioned it a couple of times.
Interlock, second one to 10. It says interlock required if alcohol related. I think it has to be the whole time she's on probation to get the penalties for violation of interlock. Yeah, because it doesn't say. But while she's riding on driving privileges, she has to have the interlock.
Okay.
Yeah, let's do that.
So that with that, well, I guess I have to talk to them, because I don't know if that means money that she needs to go into.
Right.
In
Yeah.
order to drive, since she can get driving privileges.
Yeah. So it'd be
Or just between those hours. I'll talk to them then.
I think she'll probably have to blow in that one. It'll probably be that one.
Okay,
Yeah, that interlock is still a little confusing for me.
yeah. Or is it just between the hours of her going to work?
No,
whatever the
anytime
driving
she
privileges?
get in the car, she has to have that.
She needs to
Yeah,
blow.
she has to blow.
Okay,
Especially
right.
considering where she's going to. Since, look, this is what, second one?
her second
Jump
one.
on the pole tree.
Yeah,
Yeah, isn't that
That's her second
is that your
one.
understanding of interlock? That she would have to blow every time she get in it?
That's-
as long as she's
make sure
driving.
that she's not
Okay.
intoxicated when she starts her
Okay.
car, at least.
because that may be we dealing with two different places. So
Okay.
I just want to make sure, because the one that does the house arrest doesn't do the interlock in the cars, so,
Right.
but I got it.
Okay,
Okay.
cool. So
Thank
we have
you.
a couple trials this afternoon. No jails.